Divorce litigants need and deserve basic courtroom education before evidentiary hearings and trials. Utah already requires divorcing parents to attend an orientation course under Utah Code Section 81-4-105. The reason is obvious. Divorce and child custody disputes are emotionally difficult and legally unfamiliar. But there is a major gap in the system. We orient parents to divorce generally, yet we often send them into evidentiary hearings and trials with almost no explanation of how courtroom procedure actually works. And that creates predictable problems. Most litigants have never participated in a formal evidentiary proceeding before. They do not understand what evidence actually is. They do not understand hearsay, relevance, authentication, burdens of proof, or why lawyers object. So they naturally default to what ordinary people do during conflict. They vent, interrupt, tell long stories, and argue and get defensive instead of testifying, and assume that telling the whole story is the same thing as proving a legal claim. It's not. This is because litigants aren't stupid, or not because it's an intuitive situation. Courtroom procedure is specialized and unnatural. Even many lawyers forget how unfamiliar the process feels to ordinary people. Take text messages, for example. Most people think, if the text is real, why can't the judge just read it? But courts have procedural concerns, and evidentiary ones. Who created it? Was it altered? Is it complete? Who took the screenshot? Can someone testify it is fair and accurate as a representation? The same thing happens with hearsay. Litigants constantly say things like, "my child told me," or "the teacher said," without realizing those statements often create evidentiary problems. And modern family law courts are drowning in digital evidence. Screenshot dumps, incomplete recordings, duplicated exhibits, mislabeled PDFs, and giant volumes of irrelevant communication. Judges and commissioners spend enormous amounts of time simply trying to manage confusion. So I think Utah should seriously consider a short, mandatory pre-hearing orientation course for litigants, not to turn people into lawyers and not to give them one more hoop to jump through. The goal would be procedural literacy. Teach people the difference between evidence and argument. Explain hearsay in plain English so they can recognize it. Explain how exhibits are admitted. Explain what judges can and cannot consider. Explain why more evidence is not always better evidence. Frankly, I think the benefits would be substantial. Hearings would likely become shorter, clearer, less expensive, and more focused and more accurate. Self-represented litigants would participate more effectively. Judges could spend more time deciding cases and less time managing procedural confusion. And perhaps most importantly, litigants would better understand why courts make the decisions they make. There is a difference between giving people access to a courtroom and giving them a meaningful opportunity to participate intelligently once they get there.